State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here in the matter of three separate cases today. The first case of Will Hoyt versus Genesis Hospital and others is hereby submitted without oral argument. Our first oral argument of the day is Montague versus Skinner and others. And it looks like the parties are ready. Mr. Valencia, you may begin.
Thank you, Your Honor. May it please the court, counsel. State employees, like the state itself, receive sovereign immunity from suit for tort damages, except to the extent that immunity is expressly waived by statute. And those waivers are strictly construed. So to seek tort damages against state employees here, plaintiff's claims must be sourced from one of those statutory waivers, and plaintiffs must comply with the rules our legislature has set. But plaintiff's claims here do neither. The district court should have dismissed the petition for lack of subject matter jurisdiction for two reasons. First, because the state is the employer, plaintiff's exclusive means for receiving compensation for their workplace injury is through workers' comp. That is what Section 85.2's exclusivity clause means. And second,
let's talk about that first, Mr. Valencia. This provision, which I understand has been around since 1913, says the provisions of this chapter shall be exclusive, compulsory, and obligatory. Now, why doesn't that include the gross negligence exclusion in 8520? That's one of the provisions of the chapter.
I think that would be a plausible reading, but for the last clause of 85.2, which says, except as otherwise provided in 85.1. So if you adopt plaintiff's reading that the provisions of this chapter adopts the entire chapter, then you would render superfluous the except as otherwise provided in 85.1.
Why doesn't it carve out 85.20?
Because the 85.2 itself says except as otherwise provided in 85.1. So that tells us, based in the text, that if there are exceptions, they're going to be enumerated in 85.2. Otherwise, if we read 85.2 to include a carve out and to be read as if it said, except as otherwise provided in 85.1 and 85.20, well, now we're adding words into the statute that don't exist. And there's a second reason is that if we look to 85.20, which also has an exclusivity clause, and we say that that should apply here, well, 85.2, then we're rendering the word exclusive superfluous. Plaintiffs are only giving meaning to the compulsory and obligatory part of that statute, but not the exclusive. Look
at 85.1, though. It's just identifying times when the chapter is inapplicable. So I'm not sure, I'm not following your argument that that somehow means that 8520 doesn't apply.
Yeah, it's an exclusion for, it's an exception to the exclusivity, but not an exception to the applicability of the provisions of the chapter, right?
of the chapter, if we look to them. So if we look to 85.20 sub 2, I think the history of when that subsection 2 was enacted is important to understand. So 85.20 sub 2 was not enacted until 1974. And it was enacted in 1974 in response to a case from this court called Price versus King. And so in Price versus King, you had a private employee seeking to sue their co-employee for ordinary negligence. And the defendant in that case said, well, their exclusive claim should be in workers' comp. And this court said no, because workers' comp didn't expressly extinguish pre-existing common law rights. But here what we have to look at is what were the pre-existing common law rights? And there weren't any, because state employees are different than municipal employees and they're different than private employees. The pre-existing right to sue a state employee didn't exist because of sovereign immunity.
Right to sue a state employee has existed since the 1960s without dispute, regardless of differences within our court on that issue. That cause of action's been around since the 1960s, right?
1965, the Iowa Tort Claims Act was enacted, and so then we need to look to see if the exceptions to Chapter 669. So 669.14 has the exceptions to where the Iowa Tort Claims Act doesn't cover. One of them is subsection 5, which says if your claims are within the workers' comp. Well, the Municipal Tort Claims Act has a similar provision, 670.4. And within 670.4, it excludes claims covered by workers' comp similarly.
Will the McGill case in order to reverse here?
Because 85.2 was not at issue in the McGill case. The premise of that case was this claim did exist, and the question this court had to decide in that case was, this claim exists, does it exist under Chapter 85 as a statutory claim, or did it exist under the Tort Claims Act as a common law claim? And this court decided that it...
Rule McGill or not, it certainly seems odd that this sort of silver bullet argument you're trying to raise now has never been raised in the last 50 years or so by the Attorney General. Isn't that odd?
I can't speak to why it wasn't raised in the last 50 years, but what I can speak to is what the text says. And if I might finish my thought on the Municipal Tort Claims Act, because I think it's indicative of this point, is that under 670.12, that is the Municipal Tort Claims Act, and it says, municipal employees are not personally liable for any claims exempted from the Tort Claims Act, except for claims that are permitted under 8520. So what that tells us is the legislature assumed that 8520 claims were accepted from the Tort Claims Act, which means here that they don't fall within the Tort Claims Act exclusivity or exclusion of waiver of the state's sovereign immunity, because the legislature believes that they are within 669.5, because in the Municipal Tort Claims Act's corollary statute, 669 or 670.4, excuse me, the legislature thought that the claims covered under the Workers' Comp Act were excluded from the Tort Claims Act. And that should apply here in the Iowa State Tort Claims Act as well.
To me, how under your reading of 85.2, this is another point that Mr. Rehkemper makes, is how that doesn't foreclose the employee, the state employee, from making a claim against a private third party that might be responsible for the accident. How doesn't that also foreclose that, if given your reading of exclusivity?
I don't think it would, because if that, then the analysis of Price versus King and the purpose of 669 Chapter 8520 sub 2, when it was enacted in 1974, would apply, because that would be against a private employee where there were pre-existing rights to sue your private co-employee.
Existing rights to sue the state employee, because those were around since the 1960s, or 65, right?
I would push back on that and say, no, there were not, because 670.12 tells us that claims covered under workers' comp were accepted from the Tort Claims Act. That's what 670.12 tells us. It says claims that the employees are not.
But not claims that were, and that we did, that is an issue. Now you're asking us to maybe overrule McGill, because we said that covered language doesn't apply to co-employee claims.
I think in the first instance, you don't need to overrule McGill, but our second line argument here would be that McGill needs to be overruled on this point.
Your argument that you could sue private employees, we have to say McGill was wrong, right?
I think that's right. If you're stepping to that second point, that where you don't think that the statute is unambiguous, if we're looking and we're searching to try to discern what the ambiguities mean, then I think that would require overturning McGill. And the other reasons, if there are ambiguity, other things we can look at are different tools of interpretation, like waivers of sovereign immunity should be strictly construed. We need to look for an express waiver. The general and specific canon, 85.20 applies generally to employment relationships. 85.2 applies specifically only to public employee relationships. And then, of course, the canon against superfluidity. But even if this court finds that there's a claim that exists for plaintiffs under 8520 sub 2, this court still would lack subject matter jurisdiction because the plaintiffs failed to exhaust that tort claim. And as this court said just recently last year in Anderson versus State, to exhaust your claim with the State Appeal Board, you have to comply with the State Appeal Board's form and content rules that were promulgated under its statutory authority.
Say that. What we said is, if you do comply with the form and content rules, you're fine. But even at that point, you know, I don't understand sort of the check the extra box argument. So you make this argument that because the other side, that the box on the claim form, the box for claim against employer and claim against employees, both boxes were checked, that somehow invalidates the claim as to the employees. That's your argument, right?
Yes. And I think the reason we have that argument is because of what the rules say and what the claim form itself says and what the instruction form itself says.
Rule says you're supposed to indicate which type of claim it is, but there is, in comp, there is no claim against the employer no matter what, right?
Correct.
The only claim they had against is the employees, and the body of the claim explains that they're proceeding against the employees. So your position is the claim is no good, it didn't exhaust because they checked an extra box, right?
So yes, it is that because they checked both boxes, they didn't file, under the rules, you have to file, quote, a separate claim shall be filed for each type. And they didn't file a separate claim, so they haven't complied with the rule.
Type of claim, and that was against the co-employees. They checked the co-employees box. They explained in the content, we're suing co-employees and the state is derivatively liable. So why isn't that good enough?
They tried to bring a claim against the employer, just because the claim was defunct because they might have been wrong on that statute. And then when you look at what they attached to the claim itself, they listed 50 different state employees.
In that case, what did the state's response mean? Because the state responded to it, right? They did acknowledge receipt of it.
I think if you look at that receipt at docket 43, attachment 1, page 1, it says the state is acknowledging receipt of your claim against the state, not against state employees. And secondarily, the state doesn't need to respond because there's no sort of waiver argument where we have to respond in order to preserve our arguments against the claim. This court has said that in its prior cases, that there's in Anderson, actually, where the plaintiffs there tried to say the attorney general needs to respond and ask for more information if they want it or ask for clarity. But there's no duty on that because the rules itself, the statute itself, presupposes that the attorney general might not respond.
No duty, but where the text of the claim made very clear the nature of the claim, that it was against co-employees, and then only derivatively, given the likelihood the state would substitute itself as defendant, that given that, why doesn't that satisfy the rules? That made clear what the claim was.
First, I think if you're going to go away from an analysis that requires them to comply with the rules, which is the rules that our legislature set to fall within the limited waiver of our sovereign immunity. So if you're going to go away from requiring them to comply with the rules, which they don't dispute that if a claim against the employer and a claim against the employee is different, that they didn't comply with the rules. They're going with this notice analysis.
They did comply with the rules because the text of the claim made clear the type of claim they were bringing.
Because what the rule says is, quote, a separate claim shall be filed for each type. And the beginning part of that rule says that a claim against the employee and a claim against the state is different. And so too does the claim form itself. If you look at the
And then that a claim form has to be filed with respect to each employee as well.
harder under the rules, it's not as clear, the analysis, because a separate claim shall be filed based on the type of claim. So I think if you had multiple claims against multiple employees, it's still one type of claim, a claim against an employee. But here, what the rules say is a separate type of claim, and that in a claim against the employee in the state is different. If you look at the claim form itself, it says, place an X in the box, a separate claim must be filed by each claimant for each of the 3 types of claims, and then it lists them. And then if you look at the instructions, which are at docket 54, attachment 3, it lists out type 1, general tort claim, types 2 and 3, tort claim. So there's different types.
Respect to the claims where the individual defendants who were sued in court were not identified within the claim form.
Our initial argument is that the entire claim is not exhausted because they filed it on one form, 2 claims. But if we get to this second analysis and we go with plaintiff's analysis, which is you have to give notice through the claims and compliance with the rules does not matter, then that's where we get to this argument that they didn't list 18 of these defendants that they've now sued here. They didn't list them there. So because they bring in co-employee gross negligence claims, those are very defendant specific. They turn on each defendant's.
The kind of claim processing procedure over at the board. If a claim specifically named an individual employee defendant, what kind of notice would that state employee get and what would happen?
I can't speak to what the notice the employee themselves would get. I presume, and I don't want to come up here and say assumptions, but I would presume there is some notice that goes to them, because the point of these tort claim forms is to give proper notice, to allow the state to investigate, to allow the state to determine whether this employee was within their scope of employment, so that the state knows whether they need to indemnify them or substitute in or have an action against that employee themselves. And so that I assume there is some sort of back and forth notice, but I can't speak to that particularly as to this case.
What happened in this particular case?
In the record here. And I think, again, if we're talking about notice, they listed 50 different defendants, and they've only said 6 of the defendants here in their claim. 6 of the defendants here were listed in the claim form. 18 of them weren't. So if we are going with notice, there wasn't notice as to those 18, because remember, a co-employee gross negligence claim is not just against the state where you can lump it all together. It goes defendant by defendant. You would have to do the analysis for each defendant, each defendant's actual knowledge.
Respond to the plaintiff's argument that they asked the agency and the agency refused to give them names.
Again, I don't think that the Attorney General has a duty to respond. There's not any sort of waiver type argument. That's what Anderson said. To the extent they don't have the names, though, I think that goes to the nature of what a co-employee gross negligence claim is normally you're not searching for who was grossly negligent. May I finish my answer? Typically with these co-employee gross negligence claims, they're borderline intentional torts where you know who caused this harm, and you normally don't see them against 26 different defendants, from the director of the Department of Corrections all the way down to the warden, down through the line workers that day. And I think that, so to the extent that that's an issue, it's just the way they've brought their claim against 26 different people.
Might be that they actually have claims against them, and if the state's not going to give them the names of the individuals, of the employees, I'm not sure why the fact that this might be a unique situation means that then, oh, sorry, you just didn't exhaust your remedies.
This sort of proves our initial argument about it's not about notice to whether the tort claim form gives the proper notice. It's about compliance with the rules. And so to Justice McDonald's question earlier, if they checked that they had a claim against an employee, then I think that might preserve it. But they didn't file a separate claim for their claims against employees. We only get into this back and forth about notice if we say that the compliance with the rules doesn't matter. And so I'd urge this court to stick to its analysis in Anderson and require plaintiffs to comply with the rules the legislature has set to take advantage of the express sovereign immunity waiver. Thank you.
Mr. Rehkemper.
Thank you, Your Honor. To take the Attorney General's argument, they can withhold all the critical information. They can withhold the identity of the individuals who may have offended that would give rise to a gross negligence claim. We can't possibly identify them. A plaintiff can't possibly identify them in a submission to the Tort Claims Board. Therefore, there is no way to sue under those circumstances.
Let me give you a hypothetical. Suppose you're, the decedent had been employed by a private employer and something similar had happened and you were bringing a lawsuit. You would have had 2 years, just like you had 2 years to prepare your administrative claim form, and they would have had no obligation to tell you who were the co-employees that you may have believed were responsible for the accident. This obviously wasn't an accident, the murder in this case.
Those cases, and in those cases, law enforcement provides us the reports. OSHA provides us the reports. OSHA provides us with the citations. OSHA is a state agency. The Department of Criminal Investigation that investigated these murders is a state agency. We sent specific requests to the people with knowledge, and they refused to identify. They refused to provide us the information.
Still ultimately the same. You have 2 years to identify who you're going to sue. And that would be true whether your clients, the decedent, had been employed by a government employer or a private employer. Why is it so unfair here?
The greater purpose of tort claims, and the greater purpose of tort claims, the problem that we run into here is that the legislative body and the executive branch are at odds here. Because if you look at the purpose of tort claims in Iowa, right, to sue the king, we have to jump through the king's hoops. And the king, the legislature back in the 60s, was very benevolent and did a broad waiver of sovereign immunity with specific exceptions that they withheld. Then you come to the notice requirement, the hoops that we have to jump through that are set by the legislature. The legislature set out the hoops that we have to jump through in 669.5, in writing by somebody with the authority to make the claim to the director and identify the compensation sought. Those are the hoops that the king set out. However, what we have here is the sheriff attempting to come up with new hurdles that we're supposed to come over that the king didn't say, right? So these administrative rules are not jurisdictional. This court was very clear in State versus Segura. The administrative rules for the processing and evaluation of claims are just that. The administrative agency does not have the authority to set this court's jurisdiction. That's the legislature, and that's what they did in 669.5.
That cuts against the grain of what we said in Anderson. I mean, the rules, maybe the form is one thing, but the rules do have, the rules are specifically authorized by the Tort Claims Act. The appeals board is authorized to establish rules, and claimants are expected to follow them in order for their claims to be valid.
We read 669.3, and I don't think it's contrary to what the court said in Anderson. In Anderson, the claimants did not make claims to the Tort Claims Act. The individual claimants didn't make their claims to the tort claims process. It was the administrator. The administrator survived because she had the authority to make the claim at that point in time. That's the making of the claim. But when you look at 669.3, which sets the administrative framework, I think it's important to note first, in subsection 1, the Attorney General on behalf of the state of Iowa shall consider, ascertain, adjust, compromise, settle, determine, and allow any claim that is subject to this chapter. Their job is not to find ways to trip people up and to then execute claims. Their job is to make a good faith effort to investigate and a good faith effort to then potentially settle claims. That's the whole point of tort claims, is to streamline processes and to streamline viable claims and resolve them. Instead, what they're doing is they're trying to use this as an affirmative defense to weed out claims and to avoid valid claims being made. And when you look at subsection 3 that sets out the appeals board authority to establish rules, they shall adopt rules and procedures for handling, processing, and investigating of claims. Not for filing, not for making the claims, but for processing, for evaluating, for the purposes of settlement. And that's what brings us all back to the whole reason for the Tort Claims Act was to allow citizens to make claims against the state for the torts of government employees. And it ties perfectly into the Chapter 85.
He'd be able to settle those claims with certainty if they were not aware of the identities of the potential employee defendants.
They had all the facts in their lap. They had all the information necessary. If you look at our supplement, we went above and beyond to identify the facts and circumstances. They had possession of who's working, who's doing what. They had possession of the safety audits that specifically identified tool control and inmate supervision as deficiencies at Anamosa for the years leading up to it. They had all the information necessary. If they wanted additional information from us, that we could provide them whatever they wanted. All they have to do is ask. That's the whole point. Instead, they sat silent for a year, did nothing, and now want to use it as a way to trip up a plaintiff and say, well, you didn't identify everybody possible. You didn't file 3 paper copies of each claim.
Respect, counsel, though, in Anderson, we did say the Attorney General didn't have a duty to go out and settle claims or investigate claims, and it is on the plaintiff to comply through the filing of the forms. I mean, there's no two ways about that.
Look at the forms. We filed the forms. And if you look at the forms, they self-contradict even with the administrative code, with the regulations. it's asinine now when you look at what it says on the form and what it says in the administrative rules, which is why it's so important to understand that in Segura, this court said that it's the 669.5 requirement that has to be met for jurisdictional authority to move forward with the claim, not the administrative hoops that they put out to trip people up.
To hold that you can add new names later that weren't included in your submission to the board? Okay. What would the practical consequences of that be?
Practical consequences of that are that the state doesn't get to withhold identities of people that it could be potential defendants and then say, you couldn't identify them. Ultimately, we've identified the defendants within the told portion of the statute of limitations, and we named them individually.
Apply to a private employer. I mean, if this were a case against a private employer, not the state, the private employer doesn't have any duty to disclose its identity of all of its employees who could potentially be liable to suit. And aren't we really looking at the state here as an employer, first and foremost, in that capacity about revealing information?
Distinction comes in the holder of the information. There's such a wide authority to withhold information by the state in this situation, right? What happened is a murder in the confines of a medium maximum security prison. I can't just go into there and evaluate and talk to people.
Authority to withhold information than a private employer vis-a-vis potential plaintiffs. A private employer has absolutely no duty to turn over information prior to a suit being initiated, right?
I think there's a distinction too when we're dealing with a death. I can't ask Mr. McFarland who messed up in the situation that got you hurt. I can't ask him. I have to look at the investigative files. But in this situation, the investigative files are completely within the possession of the employer, completely within the possession of the state. And they hide under this pending investigation. It's OSHA, it's this, it's that. And so they don't produce the information. So to reward them for not producing information is...
What you could have done, I'm not, even, and I tend to agree with the point that Justice McDonald is making, but, you could have filed an administrative claim early on naming the parties that you knew were grossly negligent, and I think there were some of those that were pretty easily identifiable from your perspective. And then following that following the lapse of the 6-month period, filed an action, taken discovery, and then filed another administrative claim still within 2 years.
Or something else about acknowledging in your caption unknown parties or something. Did that ever occur to you?
Did. I don't think identifying unknown parties tolls the statute of limitations, though, and I could be...
Tips off the court system, hey, we're aware there should be more plaintiffs, but we don't know who they are.
In the supplement, when we're looking at the Tort Claims Act, what we submitted to Tort Claims, we identified, I think, 50 people with potential knowledge. And if you look at the Tort Claims Act, we don't have to identify... if you look at the requirements of 669.5, there is no requirement anywhere in the code, which is the legislative set jurisdiction, to identify individual defendants at all. It's not in the code. And if it's not in the code, then that's not a jurisdictional hurdle that we have to get over.
A claim involves a party making a claim, which we discussed in Anderson, right? You got to have the right plaintiff or claimants, and you have to have a defendant.
We identified defendants, but to require us to go through and say, in essence, you'd be reading into the statute something that isn't specifically articulated in the statute. We identified 50 different people.
The Tort Claims Act, as I read it, is kind of put you on equal footing, as if you were raising a claim against a private entity or a private party for a tort claim against a private party. And if this were, again, if this were a claim against a private party, you'd have to identify your defendants within 2 years.
Of the lawsuit. That's what I did. That's what we did. In the filing of the lawsuit.
Your claim just before the end of the 2-year period, right?
Entire purpose of that claim process, if you back up and say, what's the purpose of the claim process? The purpose of the claim process is to give the state notice and an opportunity to investigate and an opportunity to resolve a claim pre-filing. That's the purpose. Yes.
Sorry. I'm bad with my light here. Doesn't that sort of presuppose, though? I mean, if the purpose is to settle the claims, and we're talking about the state being vicariously liable, right, for its employees in a lot of situations, I assume you expect that, correct? So isn't it vital that the state knows exactly who those co-employees are? If it's going to settle all the claims, it's got to know what claims it's settling.
Not, because I think what's vital is for the state to understand the incident giving rise to the claim, the incident that creates the claim. They're on notice of the situation, and the theory, which is what's required to be presented, is a general theory of the claim, but they're not required to be. It's not our duty to disclose every single individual for purposes of resolving a claim. They have
Value, the number of potential defendants, wouldn't that influence, in the state's view at least, the settlement value of the claim?
I don't think so. I think that because if you're judging damages, the damages depend upon the individual harm to the family and to the decedent, not to the state. As long as I have one grossly negligent employee, that I get the liability. Damages are completely separate, I would think.
Practical matter, I mean, in terms of the suit, does it matter how many defendants are named?
Our claim still proceeds. I think our claim still proceeds regardless, because there are named defendants in the tort claims that you dismiss, whatever. But that again, that goes contrary to the whole purpose, I believe, of the Tort Claims Act. Justice May.
I think I got my question. Counsel, is it inconsistent to say that, particularly with the work comp claim and the Iowa Tort Claims Act, is it inconsistent to say that the state is really only the defendant as a technicality, but really it's because it's a gross negligence claim against a co-employee that is outside of work comp? Is that inconsistent with now your position with respect to exhaustion, that you don't need to identify all the defendants?
100% understand. Can we try that?
Kind of the point of why you can sue the state under 85.20 is because really you're suing the co-employees, and the state has just elected to substitute itself for those co-employees. But really the only reason you can, because otherwise 85.20 says you cannot recover even for gross negligence against the employer. You're recovering against the co-employee. But so if the focus on your 85.20 sub 2 claim, so really the common law gross negligence claim is the individual co-employees, is that inconsistent with saying, I don't really need to even identify who those people are?
I'm over time. May I answer the question here? I think when we look at that, again, it's the identifying the individual co-employees at the time of filing the petition, because the petition serves a completely separate and distinct function than the filing of a claim under the Tort Claims Act, because the purpose of the Tort Claims Act is to give notice, opportunity to investigate, and settle. The petition is what determines the correct defendants in a matter. Thank you.
This court in Anderson said that compliance with the rules matters. My friend on the other side said that what really matters is giving notice of the incident giving rise to the facts. But if that were the case, then Anderson would turn out differently, because there the state had notice of the incident giving rise to the claim. But the compliance with the rules wasn't there. And the compliance with the rules is key, because that's what the legislature has said you must do to take advantage of the limited waiver of sovereign immunity. The rules do have jurisdictional effect, the administrative rules. That's what this court said in Anderson. And it's the same rule that was at issue in Anderson that's at issue here, which is Rule 1.4, which says a separate claim shall be filed for each type by each claimant. In Anderson, it was the by each claimant part of the rule, and here it's for each type. Plaintiffs don't argue that they did file a separate claim for each type if a claim against the employee is different than a claim against the state. They just say the rules don't matter. But that's contrary to waiving the limited waiver of sovereign immunity.
And for dismissal of the 18 or so people who were not named in the administrative proceedings, but later named in the lawsuit.
Our second argument. Our first argument is the exhaustion failed across the board. If
Second argument, would that outcome incentivize the state to stonewall any information exchange to hide the names of potentially grossly negligent state employees?
the reasons this court was just probing that there are ways to get that information from the state is more open than any private employer would be by statute. The state has to give over some information. And so I don't think that would, but these questions about whether the state can withhold sort of prove the folly of going with a notice analysis for what is proper exhaustion. Compliance with the rules is a much more straightforward way to decide whether exhaustion was done or not.
Requests have run into alleged exemptions for investigative materials, or would they have been turned over?
There might be some investigative exceptions, but I think there also could be some things that they could have been privy to. They didn't do that, so I don't know exactly what they could have done, but they didn't do that here, to my knowledge.
Have settled this as a package, even with some uncertainty as to which employees were named? You could have a global release, settle the claims of the estates and all employees without naming them?
I think that's hard because, again, these are claims against the employees, and so I don't know if the state could force the claimants to release all claims against some future unnamed employees. Perhaps they could, and the state in its capacity representing those state employees in their scope of employment. But that sort of gets to Justice Oxley's question that they can't really have it both ways. Their theory of why they have a claim under workers' comp is because these are claims against the state co-employees, not against the state. But then when you get to exhaustion, they flip it and they say, this is effectively just a claim against the state. As long as the state's on notice, we can add in all these other co-employees later. But the co-employee gross negligence claim is specific to each defendant. It's different than just bringing a negligence claim. Here, you have to prove each defendant's actual knowledge, each defendant's knowledge of the zone of imminent danger, each defendant's conduct. And so you can't just simply put the state on notice and then come in later with new claims that were never noticed before. And if I may, I'd just like to address one more point that I didn't address originally, which is the fallout of this court's qualified immunity cases as applied here. I don't think it has any effect. I think this court still has jurisdiction over the appeal because we took a notice of appeal of all the issues. Plaintiffs moved to dismiss our appeal. We said we're appealing all these issues. They're jurisdictional. They turn on questions of law. They should be decided now. We asked in the alternative to grant interlocutory review. And that's the difference, I think, from the court's case last Friday in the Davenport Building Hotel case. There, they applied for interlocutory review of the non-qualified immunity issues. This court denied that interlocutory appeal there. Here, the court didn't deny our application in the alternative. It just denied the motion to dismiss. So I think everything is still here before the court.
Is that all sets of issues, not just the question of qualified. And in the event we follow what we've already said and said that qualified immunity doesn't apply, we can grant discretionary or interlocutory review and reach the other issues. That's your view?
Yes. All the issues would have come up originally if qualified immunity still applied. Because of Doe and 1,000 Friends, the conduct here occurred before the effective date of the statute, and so the qualified immunity statute doesn't apply any longer, but this court still has jurisdiction over the appeal. If it didn't think that has jurisdiction, then we would ask it to grant interlocutory review here now, because these issues are just about jurisdiction.
Jurisdictional issues that we should dispose of at the beginning of the case. Is that your view?
Question. Yes, exactly. I think if we were here on qualified immunity and that still applied, you would have to first determine whether you had subject matter jurisdiction to even get to the qualified immunity issues. So those issues came up with the qualified immunity appeal, and we would ask you to decide them now because they turn on questions of law and they don't require diving into the facts here. Thank you.
Of Montague versus Beth Skinner and others is hereby submitted.